I guess I'm going to take a look at it from two perspectives. One is sort of the criminal justice perspective, and I'll share some thoughts both from the point of view of a prosecutor, but also from the point of view of a judge. And then I'll talk about civil cases and what I see there. I won't go too long. I won't take up too much of your time, but certainly if at the end anybody has questions, I'd certainly be about that topic or anything. While you have me, I would take any questions anybody might have. First, in terms of the issue of lawyers in the criminal justice system, one thing I always like to take a step back and think about when I think about the importance of defense lawyers in our criminal system. Sometimes I stop and it seems like an odd place to look for this issue, but I look back at the Constitution, and that might be one of those, it's almost cliche, federal judge just sits around looking at the Constitution all day. I don't quite look at it all day, but from time to time it's helpful to go back and see what we're actually supposed to be applying. And so I pull it up for this purpose. The Fourth Amendment, and not until recently I was a criminal procedure professor as well, and so it's fresh in my mind. The Fourth Amendment reads like this: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, no warrant shall issue but upon probable cause. And then it goes on from there. One of the things that I've always found fascinating about how that's phrased is that it's phrased from the perspective of protecting the rights of the people. It easily could have been phrased from the perspective of looking at the needs of law enforcement. The Fourth Amendment could have been phrased to say the needs of law enforcement being so significant, they shall be allowed to search individuals' homes if they have probable cause. But it wasn't. It was phrased from the purpose of the rights of the people, showing that that was their concern. The Fifth Amendment, I won't read the whole thing, but it starts out similarly. No person shall be held to answer for a crime, goes on from there. In the Sixth Amendment, in all criminal prosecutions, the accused. So all of these essential rights, all of these, really what becomes sort of, and those three amendments are really the framework for a lot of what we do in criminal courts. And I just find it interesting that they're all framed from the purpose or the perspective of the accused, the individual who's being charged with the crime. And yet, if you spend time in criminal courts, one would come away with the idea that everything is intended to be focused on the government and what the government needs to accomplish and what the government needs to do and what we allow the government to do, and certainly the resources that the government is given. That's the perspective one would have. And so one looking at that and looking at, certainly in my courthouse, the 96% conviction rate, people would look at those things and say, oh, if you were just sort of coming down from outer space and trying to assess our system, you would say, oh, when the framers, when those who created this system, they must have done it with the idea that we need to protect the rights of law enforcement, because the way things function now, that's what you see. They must have framed this so that, oh, let's make sure we give law enforcement the resources that they need, because that's what you would see if you looked at it. But the reality is, when you go back and you just look at how these amendments, these laws that are really the foundation of our system were implemented, it really actually is about protecting the rights of the people. And so who does that? Whose responsibility is that? That's the responsibility of the defense attorney. And so while it is, I certainly take no issue, especially as a former prosecutor, I'm not here to burn down the house that I used to live in. It is certainly necessary to have a well-funded, well-resourced prosecutor's office, whether it's at the state level, the city level, or the federal level. That's certainly a significant thing, because I used to have a very important job to do. But I think one thing that we sometimes need to take a step back and recognize is that the importance of having well-funded, talented, well-trained defense attorneys is just as important. And certainly when you start thinking about who does that, You think about, and I'll talk about this in a moment, sort of the Federal Defender's Office, but once you get beyond that, what you're usually dealing with are small offices, are either solo practitioners or people from small firms. And so that really becomes the focus point for who is actually doing that important work. And so again, while I think it's critical to have well-funded prosecutors, I just always find it interesting that, again, when you sit in court, you come away with the perspective that it's the United States Attorney's Office in federal court, or the State's Attorney's Office, that is sort of cloaked with or drapes itself in the flag and who is really here protecting the citizens. But really, it's the defense attorney who is protecting our rights as individuals to be free from overreach from the government. And so one would think that the resources that you see would track what is the importance of that, of those two roles. But unfortunately, that's not what you see. What you see in court more often than not is a prosecutor's office or attorneys who are incredibly well funded. In the typical criminal trial, you will see two prosecutors, you'll see an agent, so there are usually three individuals sitting at the table. You'll see boxes and boxes and boxes indicating all the evidence that they've collected, all the sort of overwhelming evidence of the defendant's guilt. And I can say from my own experience, those aren't fake boxes. They don't just stuff them with napkins and trinkets just to make it look like they have a lot there. This is actually what they've spent sort of sometimes 9 months, a year, 2 years collecting all of this evidence to prepare for trial. And then you look to the other side and you'll see, in most cases, the defendant and their one attorney. And their one attorney doesn't have boxes and boxes of materials behind them. It's interesting. I spend a lot of time talking to juries after trial. And in some courts, the judges will actually allow the attorneys to go back there. In mine, it's local rule that we don't. So I'll go back by myself with my law clerks, but I'll certainly ask them for feedback that I could give the attorneys. And one of the things that I hear the jurors say is, the prosecutors came in, and let me step back, because again, I don't know who, everybody in the audience, just so everyone understands, of course, the burden of proof is on the government, right? The burden of proof is on the government to prove its case beyond a reasonable doubt. The defense doesn't have to do anything. They could sit there, stay mute. In fact, that's why I instruct the jury. They could sit there and be quiet. They don't have to do anything throughout the trial. It's the government that has the burden of proof. What I find interesting, though, is you go back and talk to the jurors afterwards, and they will frequently say, the government, they just presented all this evidence and the defense didn't really have a response to that. The government had all these witnesses and I didn't really get from the defense that they had investigated the case the same way that the government had. That they're really, despite what the instructions are, despite what they're told, they're holding, and we get to sort of deeper, more legal questions as to whether or not some of them aren't doing their jobs in a sense, but they're clearly just, they're human beings like anyone else. They're sitting back there and they're saying, all right, there are two sides in front of me. Yes, the judge told me who has the burden of proof, but there are two sides in front of me. And my natural inclination is, if I have two sides in front of me, at some point I'm just comparing this side to this side, and whoever has the stronger case, then that's who I will ultimately side with. And so when they're doing that in this scenario, one of the things that it makes you say is, well, maybe we need to resource defense lawyers in a way that gives them the opportunity to actually compete with what they see from the government side. And just an example of what I mean, one of the things that you hear discussion about among prosecutors, defense attorneys, judges, is from a strategy point of view, should defense lawyers simply try to pick apart the government's case, or should they actually put up their own case? And clearly what we are hearing from juries is that they want to see the defense try to match what the government's doing. What defense lawyers typically do, in part I think because of their more limited resources, is they just spend their time trying to pick on what the government's done. and at times will even, as part of their presentation, seem to almost own the fact or try to, whether it's to draw sympathy, say, hey, look at how poorly resourced I am compared to the government. And that's actually part of the argument. But I think what we see with juries is that juries don't really buy that. Their expectation, rightly or wrongly, is that the defense lawyer is going to come just as equipped as the government. So just as an example, I remember one time recently, the government in its closing arguments had put together its very typical, very persuasive, overwhelming PowerPoint presentation. I'm pointing to the screen for those who can't see.